On October 24, 2019, Mr. Paul R. Hawker, a Band 6 paramedic employed by the Southwestern Ambulance Services NHS Foundation Trust, was assigned to duty with an emergency care assistant. Towards the end of their shift, they stopped at a service station in Weymouth to refuel their ambulance before returning to the Weymouth ambulance station. During this routine task, colleague 1 was responsible for refueling the vehicle while Mr. Hawker was responsible for going into the store to pay. While Mr. Hawker was inside the store handling the payment, a witness who was present at the service station noticed a member of the public seated in her car. The witness became concerned about the patient's condition, and in response to this, Mr. Hawker was alerted to the situation and approached the patient's vehicle. He failed to adequately examine the patient and told the witness he had finished shift and to call 999 before leaving the scene. After Mr. Hawker left the scene, a police officer who had stopped at the service station for fuel attended to the patient. The police officer eventually arranged for the patient to be transported to a hospital. Tragically, the patient was diagnosed with a stroke and later passed away. The Health and Care Professions Council did not allege that the registrant's actions directly contributed to the patient's passing. It is also important to note that Mr. Hawker had a differing recollection of the events that occurred and refused to take any responsibility for the allegations against him. This contributed to Mr. Hawker being struck off, as he didn't believe he had done any wrongful conduct. Despite this case occurring in the UK, it is important to examine Mr. Hawker's case under the laws and governing bodies of paramedics in Queensland. The unfolding events in Mr. Hawker's case raise issues of negligence and professional misconduct. In Australia, paramedics work under the Australian Health Practitioner Regulation Agency, who is responsible for regulating and ensuring that paramedics offer safe and effective healthcare services to the public. Their primary role is to protect the public by registering only paramedics who have received appropriate training, qualifications, and who practice competently and ethically. AHPRA is guided by the Health Practitioner Regulation National Law 2009. These codes and guidelines in Queensland are regulated under Section 39 as stated below. Negligence can be defined as a failure to take reasonable care to avoid causing injury or loss to another person. This forms part of tort law, which is a legal wrongdoing that is committed by one party or entity against another. According to the Civil Liability Act 2003, negligence requires 4 key elements to exist for medical negligence to be claimed. In order to establish negligence, the existence of a duty of care should be established. The Ambulance Service Act 1991 outlines that paramedics in Queensland have an established duty of care to protect persons from injury or death, whether or not the persons are sick or injured. According to the Ambulance Service Act 1991, the Queensland Ambulance Service's duties include the following. The paramedic in question did not provide rescue for the injured or ill person and did not provide transportation for the patient who required attention at a medical or healthcare facility. Mr. Hawker owed the plaintiff a duty of care, and this was breached as outlined in the Civil Liability Act 2003, Sections 9, subsections 1A, B and C. Furthermore, the Civil Liability Act 2003, Section 22 outlines his standard of care as a professional and states that a professional doesn't breach a duty of care if they acted in a way that was widely accepted by their peer professionals at the time. The evidence provided by the witness shows that the patient was exhibiting obvious signs of stroke. The patient was slurring her speech, she was clammy, grey, breathing heavily and had a notable facial droop. Any reasonable paramedic would arguably consider her condition was serious enough to warrant assessment and transport as per the QAS clinical practice guidelines and AHPRA standards. Therefore, Mr. Hawker breached his standard of care by acting in a way that was not widely accepted by other professionals, and he failed to provide appropriate assessments to the patient. To deem Mr. Hawker negligent, there must be a clear line of causation. Deciding liability for a breach of duty of care is determined on the balance of probabilities under Section 12 of the Civil Liability Act 2003. Damage or harm was experienced by the plaintiff because of the breach of duty of care and the actions of the defendant. This element also considers whether it is appropriate to impose full or partial liability on the defendant and the extent of the damage that the defendant should be liable for. Mr. Hawker breached his duty of care when he failed to take precautions and increased the patient's risk of mortality as per Section 9 of the Liability Act 2003. It is also important to examine the laws around professional misconduct. Professional misconduct is defined by AHPRA below. This is supported by the Queensland Health Practitioner Regulation National Law 2009, Section 5. The core allegations in this case revolve around Mr. Hawker's actions in response to the patient's condition at the service station. It is alleged that on the 24th of October 2019, Mr. Hawker failed to adequately examine or assess the patient's health despite significant concerns expressed to him by another member of the public. Furthermore, he did not recognise the potential signs of stroke, and Mr. Hawker also admitted to not completing an electronic patient clinical record or requesting the patient to sign a refusal of treatment form. Mr. Hawker also failed to work in partnership with his crewmate, colleague 1, attending police officer or his colleagues in the trust control room, ultimately breaching domains 1, 2, 3, and 5 of the AHPRA professional's capabilities. This conduct also breaches the Ambulance Service Act 1991, Section 36A, subsection B, Public Risk Notifiable Conduct, and Sections 140, subsection D, as Mr. Hawker placed the patient at risk of substantial harm in a way that constitutes a significant departure that would be obvious to any reasonable practitioner. After hearing a matter about a registered health practitioner, a reasonable tribunal may decide on one of the following. If a responsible tribunal makes a decision referred to in subsections 1b, the tribunal may decide to do one or more of the following. In alignment with Queensland law, Mr. Paul Hawker's employment was terminated on the grounds that he demonstrated professional misconduct and negligence towards the presented patient. Regarding Queensland's National Practitioner Health Regulation Law and the Ambulance Service Act 1991, as a duty of care was established, Mr. Hawker met the criteria of professional misconduct and negligence through his failure to assess, treat, transport and document this case presented to him. Furthermore, under the Civil Liability Act 2003, Hawker also breached the standard of care as his provision and professional service contributed to damage that was reasonably foreseen, and thus it was not accepted by peer health care professionals that his actions were of competent professional practice. In the situation that the allegations against Mr. Hawker's practice were investigated through an AHPRA hearing panel, his termination would be regarded as rightful due to his failure to adhere to the professional standards within the role of a paramedic.